This is Michael Popok with a Legal AF hot take. Monday is D-Day for Donald Trump. And I don't mean Donald Day. I mean the day he's got to pay up the $465 million judgment owed to the people of the state of New York by way of the New York Attorney General having obtained a judgment for persistent fraud against Donald Trump back in February. Now, there's been a lot of speculation about the fact that he can't post a bond. He even filed an irregular out-of-order paper in his reply paper, which is exactly not the place where you tell the appellate court about all of your efforts to try to raise your bond unsuccessfully. And he lied to the appellate court in doing so. He's been called out now by the New York Attorney General in her request that she respond to the reply brief. It's unusual because you're not supposed to have to respond to a reply brief. There's supposed to only be 3 briefs in a matter: the opening brief, the opposition brief, and the reply brief. The movant or the person seeking the appeal gets 2 briefs, and the other person or party like the New York Attorney General gets 1, unless in the reply brief, somebody raises new facts. And that's what Donald Trump did. And that forced the New York Attorney General to ask permission to file what's called a SUR, S-U-R, reply brief, a SUR reply brief, a reply on the reply. And in it, they pointed out, as I've done on a prior hot take, all the things that were missing from the filing by Donald Trump saying he couldn't raise his bond, and all of the improper and just plain wrong factual assertions in there by people, particularly affiants, people who filed affidavits that have already been found by the New York judge, Judge Engoron, to lack credibility and or to be involved in the very fraud that the Donald Trump is involved with. Yes, Donald Trump used at least one person, Alan Garten, his general counsel, who was already judged by the Judge Engoron to have been a participant in the very fraud that created the judgment for which they are seeking the bond. But to Donald Trump, he's like, put Alan Garten in, let him file an affidavit. New York Attorney General, of course, pointed out Alan Garten is the last person that should be believed on the efforts that have been made by the Trump organization. And he also pointed out, on behalf of the New York Attorney General, the person that filed this, about the things that are missing, that there's no credible evidence having been provided by Donald Trump. There's no affidavits from banks that say what loans he tried to take out from them, or what bonds he tried to obtain for them, or what irrevocable letters of credit and why they rejected it, or what property he offered and why it was rejected, and what surety companies, bonding companies, insurance companies he went to for a bond and why they rejected it, and what assets he provided. You know, all the things that would go into a court understanding and not just taking you on your word as somebody who's already been found to be committed fraud in New York. Maybe we shouldn't take you at your word, especially when you provide affidavits from people who participated in the fraud. You got to go beyond that. And the New York Attorney General said, you can't believe a word they say. You can't believe a word the people that filed the affidavits for them say. The judges already found them to be not reliable and or participating in the very fraud itself. And where are the missing affidavits? Where are the banks? Where are the surety companies? Where's the issues about what assets were provided? Where are the details? If you're going to ask the court, the appellate court, to allow you to post less than the full amount of your bond requirement, $465 million, where is the other material missing? Now, there's speculation in New York, although I'm going to tell you I disagree with it. But I've read the tabloids that Donald Trump believes he's going to win, and he's going to let Letitia James on Monday start confiscating and selling, levying on his property. Like she's going to show up with the sheriff and padlock Trump Tower or Trump International or Trump World, any of these buildings, or 40 Wall Street, or go down to Mar-a-Lago. And he's going to let her do it, hoping that if he wins on appeal, he'll reverse the judgment. But all he'll get back if that happens. That's why I don't believe this theory that Donald Trump is okay on Monday with Letitia James seizing his assets and starting to sell them, is that he'd never get the building back. He'd never get 40 Wall Street back, even if he reversed the judgment. You know, once she sold it by way of a sheriff's sale to a bona fide purchaser, we call it a BFP. Once a bona fide purchaser buys it, the bona fide purchaser takes it without any defenses against it. Donald Trump can't show up one day and go, hey, Mr. Bonafide Purchaser, BFP, bought it at a sheriff's sale, free of any liens, I own the building. I just got a judgment. I won. And he's like, that's great, old man. You don't own this building. I got this building through a proper sheriff's sale. All that Donald Trump can get is the money back if he were to win and prevail on attorney's fees. But that's only after the assets were liquidated. So that's not going to happen. That's not going to happen. And as the Attorney General reminded the appellate court, as if they had to, and I guess Donald Trump, he had alternate ways to pledge assets to secure the judgment other than a bond. He could pledge collateral. He could ask the court for permission. He could go to Judge Engoron and have said to Judge Engoron, I got a $450 million judgment. I've got deeds here in my hands for property that has been appraised by a legitimate appraiser, and that's going a long way for Donald Trump, at over $550 million, let's say. Take these deeds, hold them in the court registry, in a safe in the court. That's going to be my pledged assets to stop the enforcement of the judgment. And if I win, I get the deeds back. And if I lose, they get the deeds. I mean, courts don't love it, but he could have gone and, as the Attorney General proposed, and made that proposal to Judge Engoron with deeds in hand. Here's the deed to Mar-a-Lago. How ironic. We think it's worth $1 billion. The judge could say, I don't think so. What other deeds do you have? This could have been a giant game of Monopoly, where he comes with this is Park Place, and this is Marvin Gardens, and this is hotels that I own on those those houses that I own. And here's deeds until the judge says, okay, enough, I got it. I think there's a pile here of $600 million in deeds. I'm going to hold on to these as pledged assets. So you can't transfer them. I got the deeds against the judgment. And we'll see what happens on the appeal. He never did that, as the New York Attorney General pointed out in their proposed papers. So there are a number of ways, including breaking up the bond. He kept saying, Alan Garten, the general counsel, and this other guy that was already discredited as an expert, Giulietti, not Giuliani, he was discredited too, but Giulietti, who filed the affidavit. He said, I'm the broker. I'm trying to help the Trump organization get the bonds. He's made over $1 million working for the Trump organization. He's biased. He's not an expert. He's not an expert in the bonding area at all, ever. And so for him to say, I tried to get a bond. Nobody wants to give a $565 million plus bond. Sure they do. You syndicate it. You syndicate the bond, which means you sell off parts of it to different surety companies who join together and collectively put up the $565 million. Happens all the time. Chubb Insurance is in for $100 million. Northwestern Insurance is in for $50, right? National Re is in for $100 million. Lloyd's of London is in for $150 million. And they work out the priorities. But a broker puts together a package of and they syndicate this bond, just like they syndicate a loan when it's so large that no one banker wants to take on that risk. No one surety wants to take on that risk. You syndicate it. And there's no mention of that in the papers filed by Donald Trump, that he attempted to syndicate anything. So I love the New York Attorney General for many reasons. In a very short, succinct, efficient 5 pages, they tell the appellate court, where's the beef, right? Where's the pledged assets? Where's the attempt to bring the deeds into court and have that be in lieu of a bond? There's ways to do things in lieu of the bond. And if you and I'm not telling you to go get the bond. Where is your efforts to syndicate the bond? You said Chubb Insurance was interested, and then at the end they declined. What were they provided? What was the information? What was the assets that you pledged or offered to pledge? Where is that information in any of the affidavits submitted by one person who was involved with the fraud, Alan Garten, and another person who benefits from the Trump organization to the tune of over $1 million a year, who's not an expert in the area of bonds? You're trying to get an appellate court to pull the emergency brake and stop on Monday Letitia James from selling assets. You got to do better than a guy who committed the fraud and was involved in it, a guy who's not qualified to talk about bonds. Where's your real bond expert to submit an affidavit on time, appropriately in the case? Too late now. Where are your bank affidavits? Where are your surety affidavits? Where's your insurance affidavits? Where is the affidavit from Barbara Jones, the monitor, who sits over all of the assets of the Trump organization for the last 16 months? Missing. So I want to just kill any speculation out there through this hot take that Donald Trump didn't have alternatives. He did. Pledging assets to asking the judge to accept deeds in lieu of a bond for property that equaled the amount, supported by proper appraisals. Go out and get proper appraisals from a big four real estate brokerage, a real estate firm that's well respected. I can name them all in New York, and come in with the appraisal. Here's Mar-a-Lago appraised at $550 million. Here's 40 Wall Street at $550 million. Here's my apartment at the triplex, $100 million. Here's my whatever. Here's enough deeds to triple cover the judgment, judge. Take them, hold them until our appeal is over. That's how confident we are we're going to win. He didn't do that. Or here's my efforts to syndicate and they failed. I couldn't get a crowdfunding source of bonding companies from around the world to invest in me. That may be true, but where's the proof that you tried? And without it, Monday is auction day and seizure day. That's the D-Day that we're talking about here on this hot take. So we'll continue to follow it all on the midweek edition of Legal AF and on the weekend edition of Legal AF, that podcast that sits at the intersection of law and politics. We'll bring it to you here and on hot takes just like this one. You like these kind of hot takes with lawyers talking about things that they know what they're talking about at the intersection of law and politics? You've come to the right place. Legal AF and the MeidasTouch Network, helping them get to 3 million free subscribers. You're already here. Don't change the dial. So until my next hot take, this is Michael Popok at MS Popok. Leave me a thumbs up, leave a comment, helps with the ratings, helps acknowledge to the algorithmic gods that you like the content. Until my next hot take, until my next Legal AF, it's Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.